So good afternoon. My name is Tom Hughes. I'm a Senior Market Services Executive at the IUA, and I'll be chairing our session this afternoon. So thank you very much for joining. This is, of course, session 2 in our series of 4 aviation wordings masterclasses that are being hosted by the IUA's Junior Aviation Practitioners Working Group. So I know, of course, for many of you, we are saying welcome back following session 1 on Tuesday. We hope you found that session useful. Before we get started, I will just reiterate a couple of points that we mentioned last time. We will be recording the session and circulating a link to the recording and, of course, the presentation slides following the event. You may have already noticed we do have a Q&A facility within the webinar platform. It's just at the bottom of your screen, so please do make full use of that, and I'll be pleased to put your questions to the speakers. And then do look out as well for some polls that we'll be running at various points during the session, of course, just to make sure everybody is alert on this Friday afternoon. But please do participate. We're really keen to hear what you think about the various questions we're posing. And of course, the feedback will all be anonymized before we have a look. The last thing to say is that we did send a clause pack around ahead of the session. Hopefully you received a copy of that from Deborah Finch, so please do take a look. It might be a useful reference point either during or after the session. So just in terms of the questions that we receive, of course, we are all here to learn and there really are no incorrect questions. However, it's important to note that our speakers are here to provide their individual views on the rationale behind model aviation clauses and of course their theoretical operation only. And that does mean that we won't be answering any questions related to ongoing coverage matters in the market. So do refrain from asking those questions if at all possible. So I think, Tony, we can move on to the next slide now. We'll just take a very quick look at the format for our aviation masterclasses. So as I said, we've had session 1, here we are on session 2, considering the intent and effect of core aviation exclusions. There are 2 more sessions coming up. You can still sign up for those. And then we move into our claims masterclasses, 2 sessions on the 13th and then the 17th of May. And we'll be using a claims scenario, a large loss, to try and look at some of those key points that need to be considered during the claims handling process. So I think we can move on to the next slide now, and I'll just quickly introduce our speakers. So we have Jette Varnels. Jette is Technical and Wordings Manager of Aerospace at AXA XL. We've got Gareth Howe. Gareth is Underwriting Technical Director at Global Aerospace, and Sophie Moisan. Sophie is Chief Legal, Claims Advisory and Institutional Officer at La Réunion Aérienne. So with that, and we are of course very fortunate to be joined by our speakers. So thanks again to Sophie, Jette and Gareth. And we'll just take a quick look at our first audience poll, if that's okay, Tony. So hopefully that should pop up on screen in a moment. A very simple one. We're just checking who was able to attend the first session. Will give us a good idea of who we have today and who we may be welcoming for the first time. And there is a note there in case you did receive the recording as well. We'll hold on for a few seconds. And I think, Tony, perhaps we can pull up the results. Excellent. So we have just under half joined the first session. We have plenty of people joining for the first time, which is fantastic, and several people that didn't join but did receive the recording. So hopefully you've had a chance to have a look at that, or we'll be able to ahead of perhaps the next session. So Tony, I think we've got one more poll before we move into the presentation itself. And we just wanted to take a quick look at those that we have got joining on the call today to understand how long you've actually been working in the aviation insurance market. So we've got 0 to 2 years, 3 to 5, 6 to 9, and 10 plus. And of course, there may be some people who don't work in the aviation market at all, which is equally absolutely fine. Just allow a few more seconds. And I think, Tony, perhaps we'll pull up the results. There we go. Okay, so we've got a slim majority of people that are 0 to 2 years in the market. Of course, fantastic to see lots of new entrants. We have just under 20%, 3 to 5, just over 10%, 6 to 9 years, and then actually 34%, so pretty close to being the majority over 10 years, and a couple of people who are outside the market. Okay, thank you very much for your participations. Do keep a lookout, as we do have a few more of those. I think we can move on to the next slide and pose a couple of questions as promised from our first Wordings Masterclass session. We did have a couple of questions coming after the event, which is exactly what we were hoping to receive. So thank you all for your engagement. So the first question, Yeda, I'm going to put to you, and that's in respect of LSW 555D and specifically General Exclusion D, which is any debt, failure to provide bond or security, or any other financial cause under court order or otherwise. So the question we received is, why are these words included on a war wording? Is this in respect of aircraft finance agreements? If you could summarize your answer for me, that would be fantastic.
Yes, I can do that. Thank you. And it's a good question, but it's actually nothing to do in its origin with the AV67. It is to do with the perils insured under the confiscation section, and to ensure that that a claim isn't presented on the basis of I can't get the aircraft back because the operator or anybody else hasn't paid fees and other monies that are dues to an authority, and that the aircraft is simply being detained for unpaid debts. So those debts, you know, there's nothing fortuitous about that, and we wouldn't want to pay those claims. And that's why it's fairly strict and wide exclusion to take those things into consideration. So that's what it was there for. 67 actually came in later, and of course there may be an impact, but again, a spat between a lessor and a lessee shouldn't constitute a claim under 67.
That's excellent. Thank you very much, Yeda. So the next question I'll put to you, Sophie. We had one regarding the schedule. If leased aircraft are shown on a schedule, who is responsible for including AVN 67 all risk and whole war within AVN 1C? Would that be the insured, the broker, or the lead insurer?
Well, clearly the duty arises from the lease agreement for the insured to check that he's got the required coverage and protection for the lessors. So it's primarily the duty of the insured under the lease agreement. Then, of course, the broker, as an agent of the insured, is responsible to ensure that indeed the coverage is present in the policy wording. This cannot be a duty of the insurers. The insurers have no knowledge of the agreement that may be passed between the insured and third parties. So, in short, it's both the insured and the broker's duty to ensure that the protection for the lessors is present in the policy.
Thank you very much, Sophie. I think that's really clear, and I hope that's answered the question that we received. And next, I'll pass a question on to you, Gareth, and you've got the tough task of having two questions and only a minute or so to answer them. But the question is, with regard to AVN 1C and the all risk section, for emergency expenses, are 10% of agreed value or 10% of incurred hull damages paid on top of the hull loss itself?
Yeah, thanks, Tom. So yeah, under the hull section of AVN 1C, we have this additional emergency expenses provision to provide for immediate safety of the aircraft. And the amount that's available is up to 10% of the agreed value of the aircraft. The actual value of the loss is not relevant. So it is up to 10% of the agreed value.
Excellent. I think that's pretty clear. And with that in mind, we can move on to the final question that we received. So it was brought to our attention that circumstances have been seen where AVN 59 has been agreed on a general aviation slip covering aircraft liability, which is AVN 1C, and non-aircraft liability, which is 48 fly. Is that the intended use of AVN 59?
Yeah, thanks, Tom. Yeah, so we covered AVN 59 very briefly at the end of my AVN 1C section, but the two are not related. So AVN 59 shouldn't be used on an AVN 1C risk. nor for that matter should it be used on any standard aviation form. It's designed to be used for a bespoke airline placement. That's the intention for AVN 59.
Okay, well, thank you very much, Gareth. And I think we're just about in time to start our first presentation. So I think I'll be handing over to Yeda, and we'll move on to the first slide. Yeda will be talking about AVS 104B. Thank you.
Thank you. And thank you for the slide, Tony. And welcome to the second session. We are AVS 104B, General Policy Exclusion, was introduced along with AV59 that Gareth mentioned earlier, and was really intended as a best practice document. In the late 70s and into the 80s, airline operations broadened, and there was a lot of extra activities that the airline was undertaking, and the policies, because they were in a defined universe, i.e. Operating aircraft, they were built on the basis of we cover that which isn't excluded. But once they started to get into running hotels and travel agents, etc., more sort of exposure was introduced into the into the aviation policy, and it was felt that that was unreasonable. So we therefore, along with the introduction of the personal injury extension clause, AVN60, which we'll get to in a later session, this best practice document was drawn up along with AVN59 to really make it clear that the aviation policy for an airline covers the aviation exposures, that those are connected to the operation of aircraft. And so if we take these exclusions from the top, they're a generic phraseology. It's saying that the best practice is that an aviation liability policy should include the following exclusions. Now, it's not being prescriptive in how they should be included, but they should include them. And often these exclusions can be modified. At the foot of AVS 104B, it does provide that deviations from this list can be made subject to underwriters' agreement. And obviously, manuscript wordings are bespoke. So they are aligned to the insured's operations and that which has been negotiated to be included in that contract. So it's very normal, and all liability policies would include a contract exclusion, but these are often modified, and I'm sure that anybody who deals with liability slips will see that there is often automatic provision to include certain entities within the usual scope of the insured's business. The next exclusion, vehicles and automobiles, is really a Road Traffic Act exclusion, is how it's often referred to. Again, there can be some variations, but the intent is that the aviation insurers can't be providing insurance for the operation of vehicles where compulsory motor insurance is required. In many cases, aviation insurance wouldn't be licensed to do that. But the intention is also to not exclude the operation of vehicles airside. So the exclusion as we see it here is very rarely now used in that format on a wording. It has been modified, but you'll get familiar with that as you get more familiar with wordings and the coverage. The third exclusion is bodily injury and or sickness or disease or death of any employee arising out of and in the course of his and her employment. And that is because if it is not intended that the aviation policy, which is meant to be a third party liability policy, passengers and or other third parties, employees should not be considered to be third parties. They should be adequately covered by their employer, the insured, under an employer's liability policy. And we will often see that there's additional language to this exclusion 3 that says, or any liability that's expected to be covered or required to be covered under employer's liability or workers' compensation. But the intention is that employer's liability or injury to employees should not fall to the aviation policy. The insured should have an appropriate policy for that coverage elsewhere outside of the aviation. The fourth one is hiring and hiring employment dismissal procedures of the insured. Again, this is not an aviation matter. This is a general business matter, and therefore should be again something that would customarily be covered under an employer's liability policy. Now, the liability policy is a third-party liability, third-party coverage. So therefore, it's obviously shouldn't be covering damage to property owned, rented, leased, loaned, or occupied by the insured. There should be appropriate first-party or property insurances in place to cover those liabilities. That said, it is possible in certain areas to have a limited right back for this. But again, this is permitted because it's the language at the foot of the clause which says that you can deviate with everyone's agreement. Illegal or criminal activities are dishonest or acts alleged or otherwise committed. We sometimes have policies where this isn't included specifically, or it may be included as a condition as opposed to an exclusion. However, clearly the policy should not cover deliberate illegal acts by the insured. Years ago, there used to be a specific knowledge and consent clause, which had different language. So, illegal activities with the knowledge of the management is not something that should be covered under any policy, to be honest. Fiduciary responsibility relates to handling of monies and funds, etc. And again, this is not an aviation specific risk, and therefore should be a risk that is covered by a specific policy that any business would take out as it deems necessary. The exclusion 8, inefficacy, is one that sometimes causes confusion. There's examples of what such an exclusion looks like, and basically it relates to the cost of repairing or replacing defective goods, etc. And where we have got cover for the activity, then it is appropriate that this exclusion is in there. But what we have to remember is that the exclusion will not exclude loss of or damage arising from the inadequate performance or design or improper specification, etc. That's the same as we will see in the premises. Then can I have the next slide, please, Tony? And the next exclusion is noise and pollution hazards. We will get to those. The common clause is AV46B, and basically the aviation policy should not be in lieu of an environmental policy as we see them now, but it will cover sudden and accidental exposure arising from the operation of aircraft. War and allied perils, our standard clause is AV48B. We talked about that in the previous session. Not all markets would use the AV48B, but may use a variation thereof. And again, most of those perils under that clause can be written back subject to separate conditions. The radioactive contamination exclusion 11 is now nuclear. It's the nuclear risk exclusion, currently AV38B of 71, and basically nuclear risks are not insurable in the standard aviation market. And then we get to the risks that sort of triggered this best practice, which is the ownership or operation of hotels, leisure resorts, social clubs and sport complexes. Sometimes we might see that there's a right back for a social club, an airline social club, etc. But it was really to avoid the other activities that an airline might get involved in operating hotels and the like, which is not an aviation exposure. They should be purchasing appropriate insurance otherwise. And shops and restaurants, that started off as sorry, got ahead of myself. Tour operators, travel agents, and again that we're only covering the that which is required under a contract of carriage by air. The other travel agent activities are not for the aviation policy. Shops and restaurants, again, these are activities that are not specific to aviation, and therefore they should be purchasing their own or separate policy for it. And it would not be, it should not be appropriate to have it under the aviation policy, although ticket office, etc., are specifically excluded from this exclusion because they are potentially considered as the operator's premises, aviation premises, where we do give cover. Item 15, advertising activities. That is it's generally modified to say that this exclusion does not apply to bodily injury or property damage arising out of these advertising activities, and that's because as it's written here, if an advertising sign fell down and hurt somebody at an airport, for example, then it would not be appropriate to have that excluded. But it is, of course, an advertising activity, so we get the right back for that. Similar, the promotional activities and sponsorship activities should not be activities that should be covered under the aviation third-party liability policy unless they are very specific and directly related to the operation of aircraft or conducted at airport premises. So, and as I said, the list can be modified. We often see right backs for various parts of it. There might be something on the bodily injury to employees. We might define when an employee can be covered under the policy, perhaps as a passenger, etc. But that's how how it will be agreed by the insurers and negotiated with the broker. And I hope that was a quick canter through this clause, but it hopefully just explains where insurers are coming from and what best practice looks like. Thank you.
Yeah, just before we move on, if it's okay, we've had one question that has come up, which I wanted to bring to your attention and just ask for a quick response if we can. So the question is, we see countless quotes that do not incorporate AVN59 and AVS104B, which are put on, but why do you think we don't see these clauses very often? So I don't know if you've got a quick comment to that one.
Well, we would only expect to see AV59 and AVS104 on manuscript wordings. So if the quote is being submitted on the basis of a standard form, as Gareth said earlier, these clauses wouldn't come into play. AV1C is very specific aircraft operations only, and therefore it wouldn't cover any of these additional exposures. And 59 wouldn't come into play because it is only operating aircraft. Similar for the airport owners and operators policy, whether it's a Fly 48 or the AVN126, it is an aviation premises policy. So it is aviation locations. So therefore we wouldn't see them. We should only expect to see 59 and 104 where we are looking at a manuscript style wording.
That's excellent.
Sorry, that was a bit long-winded, wasn't it?
No, not at all. Thank you very much. Okay, I think we'll move on now to Gareth, if we can have the next slide. Thank you very much.
Thanks, Tom. And it falls to me to talk about some of the exclusions, the core exclusions. Yeda touched on them very briefly within ABS 104B, and I'll talk about those and a couple of others. The first one up is AVN38B, the nuclear risks exclusion. And I hope it's not just me, but every time I look at this clause, I think, oh, why is it so complicated to have a nuclear exclusion that runs on for so long? So hopefully I'm going to demystify some of that today. The first part of the clause, paragraph 1, sorry, actually, let me backtrack. I should say that this clause applies to hull and liability and has been drafted for use on every aviation policy. So we should see it on every aviation risk that's out there. Paragraph 1, the first part of the clause, is a complete nuclear exclusion, and it's very broad by intention. So part I there is any property damage of any nature whatsoever, and part II is any legal liability of whatsoever nature. And then we have 3 triggers, I guess, A, B, and C. So, and I should have highlighted, just for nuclear assembly, I should have highlighted explosive nuclear assembly. So that paragraph A is the first part of the exclusion. And that part is never written back. That is always excluded, a bit like paragraph B of AVN48B that Yeda spoke about last time. The second one, B, is radioactive properties of materials whilst they're in the course of carriage as cargo, including whilst they're being stored or handled. And the final part, C, is ionizing radiations. So taken as a whole, that part 1 is an absolute exclusion for property damage and liability arising out of those 3 triggers. Tony, if we go to the next slide. The next part of the clause then are some limited write-backs, but only in relation to B and C that we saw previously. As I said, paragraph A is never written back. Paragraphs B and C are written back in a limited way. So the radioactive properties and the ionizing radiations that we talked about do not include depleted uranium or natural uranium, and radioisotopes in the final stage of fabrication. So if you've got nuclear materials being used in a medical application or a scientific application, they're being loaded onto the aircraft, carried as cargo, that's not intended to be excluded by 38B. So that's the extent of the limited write back. Tony, if we go on, we then have paragraph 3. And this paragraph is basically summed up as making sure that insurers don't cover losses that would be indemnified elsewhere. So the 3 scenarios are: 1, where there's another insurance policy. The second is where the insured is required to maintain financial protection under legislation, which would mean that it wouldn't fall to aviation insurers to provide that financial protection. And the third element is where there's a government indemnity for the nuclear activity that's taking place. So the purpose of paragraph 3 is to make it clear that aviation insurers are not going to pick up claims in any of these 3 scenarios. Tony, if we go to the next slide, please. The 4th paragraph then really are conditions that relate to paragraph 2. So the limited write-backs that we talked about, where you've got depleted or natural uranium, and materials when they're at the final stage of fabrication, there are some conditions relating to when coverage will be provided for those. And it is rather wordy, this part of the clause, but basically it sums up as meaning that you have to comply with some strict requirements for how those goods can be handled. So if you're carrying, this really relates to airline operations, where you're carrying nuclear materials as cargo, you have to comply with the ICAO guidelines on how they should be carried. There's then this part at the bottom there, this table with these random amounts that I'm not going to attempt to explain, but the IAEA health and safety regulations is basically the International Atomic Energy Agency, and they set standards for the safe use of nuclear materials. So that the scales, we as aviation practitioners don't need to understand what the scales mean, but that's the origin of where that has come from. And the scales relate to the fact that loss or destruction or damage to or loss of use of an aircraft must have exceeded the maximum permissible level set out in those scales. And then the final point on AVN 38B, which Tony is on the next slide, is a cancellation provision, so that the limited cover provided by the paragraph 2 right back may be cancelled at any time by insurers by giving 7 days notice of cancellation. And that hopefully summarises AVN 38B. I do realise it is quite a wordy clause, and it is worth reading a few times to get your head around. Tony, if we go to the next slide. Now, 38B is the clause, the nuclear clause that you're going to see on the vast majority of risks, but there is another option out there, which is AVN71. And this is an absolute nuclear exclusion with no right backs at all. And this would be used where it was considered unsuitable to use 38B, but it would not be appropriate in any case to use this where it's an aircraft operation. So you may see this on a non-aircraft operation risk, although it is quite rare to see it used other than 38B. Tony, can we go to the next slide, please? So the next clause that I wanted to talk about is AVN46B. And in my opinion, of the core exclusions, this is the one that is most likely to come up when we're discussing claims and potential claim scenarios and whether something may be covered or excluded. This is the one that seems to generate the most questions. So it's a third-party liability exclusion. It has quite a broad trigger about claims directly or indirectly occasioned by, happening through, or in consequence of. And then we have these 4 perils. So the first one, noise, fairly self-explanatory. The second one, pollution and contamination of any kind whatsoever. And it's worth pointing out that that is a very broad pollution exclusion, and intentionally so. The third one, electrical and electromagnetic interference, again, fairly self-explanatory. And the fourth one, interference with the use of property, which sometimes confuses me. And one of my panelists might correct me because I didn't consult with them on this previously, but I believe this originates from the possible impact of low-flying aircraft that may interfere with the use of property. I believe that was the origin of paragraph D. And then we come to probably the most important part of the exclusion clause, which is the right back. So notwithstanding we're excluding noise, pollution, electromagnetic interference and interference with the use of property, there is a right back. So the excluded perils do not preclude a claim which will result in an aircraft accident or abnormal operation of the aircraft. So the core coverage that we're providing for an aircraft accident is always preserved. And it's not the intention of 46B to not cover an aircraft accident claim. Tony, if we move on, you've got 46B in your pack, so I haven't put these up in totality, but paragraph 2 basically says that insurers are not required to defend claims that are excluded by 46B. And paragraph 3 says that combined claims, where you have a scenario where it's part covered and part excluded, will be partially covered by 46B. Tony, next slide. Sorry, just before we finish on 46B, I should say that there are 2 standard amendments that are generally made. The first is that 46B doesn't apply to passengers for an aircraft operator. So if you have a passenger liability claim, the perils of 46B do not come into play. And the second, that if you have product liability cover given, then paragraph 1B, the pollution paragraph, is not applicable to pollution or contamination of goods and products sold or supplied by the insured. I just wanted to make clear, because that one does generate a little bit of confusion. It's pollution or contamination of the goods or products that are sold or supplied. The right back is not for pollution that's caused by a product sold or supplied by the insured. And there is a subtle distinction there, which it's important to recognize. So the next clause that I'm going to talk about is the asbestos exclusion. It's a third-party exclusion, and it is quite broad. Presence of asbestos in any form, any claims relating to that are not covered. And then a whole raft of things there talking about testing, monitoring, cleaning, removing, relating to the presence of asbestos. They're not covered by the aviation policy at all. But then we have the right back, which is as per AVN46B. So the core coverage is preserved so that if we have the aircraft accident and there is some asbestos that somehow relates to that aircraft accident, then that shall not preclude the claim. The final paragraph of the asbestos exclusion says that there's no duty to defend the excluded claims. Now, I just wanted to touch on one point, that is that we've used this 2488 AGM asbestos exclusion, which is the one that you're going to see almost all the time. There is an AVN asbestos exclusion, AVN96, but it's not used. And the reason for that really is that the right back that we've highlighted on the screen is not included within the AVN96 clause. Tony, next slide. I think that was my last one on those exclusion clauses.
Thank you very much, Gareth. I think that was a really useful stop across a few clauses there. So thank you very much. And we have had a question, which is good because we've just approached the Q&A break. And I would remind everyone, please do make full use of the Q&A. I know we've already had a few questions, so please do keep them coming, and we'll try to ensure the session is as interactive as possible. So Gareth, this is one for you, and I think it's actually probably a stylistic point and something that may have evolved over time, but please do correct me if I'm wrong. So the question is there a reason why crash, fire, explosion under 46B, and there are a couple of other examples of this, I think, are expressed without commas? So it simply reads crash, fire, explosion, and there's no punctuation between the words.
Yeah, it's a very interesting point, that one, Tom. And if I'm honest, I don't know the origin of why there were not commas put into that clause, or whether it was a conscious decision not to do so. One of the challenges we have, and this subject gets debated quite often, as to how far that right back is intended to sort of go out. One of the issues we have is that, to our knowledge, this clause has never been tested under English law. So we don't fully know how that would be interpreted by the courts, and indeed it may be interpreted differently in different scenarios. It's a bit of a woolly answer, but I don't know the origin, and I'm not entirely sure that I can comment on the legal ramifications of there being commas or not commas within that right back.
That sounds wise, Gareth. I know that there are a couple of examples of cases out there that were quite widely publicised, having turned on the difference between a comma being present and not. Do either Yeda or Sophie want to come in on this particular question?
No, I can add to what Gareth said, that that it is something that is debated from time to time, but again, the whether the commas are in or not hasn't impacted on any claim to date, so it's not been tested in court, as far as I'm aware. Okay,
thank you very much for that, Yeda, which means we can move on to a question again. I think we'll put this to you first, Gareth. So the question is, why is asbestos not captured by the pollution and contamination exclusion?
Yeah, thanks, Tom. It's purely a timing issue. So the pollution and contamination exclusion existed long before the asbestos exclusion was introduced. After the asbestos issues that were suffered by the insurance market, that's when the asbestos exclusions were introduced, and I don't know the exact year that that AGM clause was introduced. I think it was around 2000, probably. Yeda might know the exact date. But it's just a timing issue. If the clauses were to be redrafted today, then they would absolutely be incorporated together, I believe.
I don't know exactly when the clauses were introduced, although I do remember them being introduced and there being quite a debate And you'll note that the asbestos clause that is an AGM clause, which makes it an underwriter clause, not a market published clause, but it is a market accepted clause. There is a debate as to whether asbestos would already be fully and adequately excluded by the language in AV46B, but there was enormous concern, particularly from the US, and the US started introducing asbestos exclusion clauses, and they included mold and some other things in there as well. And it was just felt prudent, I think, to bring in a specific asbestos exclusion clause.
And it may have been, with, of course, trusty Google in mind, 2012. Don't know if that sounds about right.
It would have been a bit after, well, around about the same time as AVN96. 96 is not recommended for use at all, and that was issued by the Joint Clauses Committee before AICG came into effect.
Perhaps not then. Maybe Google hasn't been quite so trusty this time. I'm sure we'll find the answer, or if somebody may know the answer and can paste it into the chat for us.
Well,
perhaps that's our first challenge.
The underwriting, the underwriter that introduced the clause might know. So.
You would hope so, yeah, wouldn't you? Okay, so I think we may now be able to move on. As I can see, we haven't got any more questions for the time being, but we